Okay, let's get started. Welcome everyone to the Access to Justice training this morning. We're going to be talking about the impact of drugs and guns with recent Seventh Circuit developments. We are Diana Rashid and I'm Dave Faraday. Diana is a supervising attorney at NIJC's detention project, and I am a staff attorney with Diana on the detention project as well. So today we're going to be talking about recent developments in Seventh Circuit law on drugs and firearms offenses, which relate to various grounds of removability under the INA, including controlled substance offenses, drug trafficking, aggravated felonies, crimes involving moral turpitude, the reason to believe standard for a drug trafficker, ground of inadmissibility. And then we'll be talking about firearms offenses and firearms related aggravated felonies. So as we go through the presentation today, please feel free to type questions in the chat or the question boxes. We'll be trying to monitor them as we go. Please feel free to do that, and we'll try to answer them as we're on each topic, so we don't have to wait until the end. We will have questions, we'll have time at the end to talk about questions as well, but if you'd like to do it as we go, that's fine, that's great. And we're also recording this for use later. Let me just try to advance. Okay, so just an overview, we know that the grounds of removability, you could be charged with inadmissibility under section 212 of the INA, or you could be charged with deportability under section 237 of the INA. And so there are differences between grounds of inadmissibility and deportability. These are some examples of grounds of inadmissibility under section 212 A2. You've got the CIMTs, crimes involving moral turpitude. You have controlled substances offenses in which an admission to a controlled substance offense is sufficient for a ground of inadmissibility. You also have the drug trafficking, you also have the drug trafficking standard, which is the reason to believe someone is a drug trafficker standard under inadmissibility grounds. And you have these other grounds of inadmissibility. And today we'll be talking about the two bolded sections, the controlled substances offenses and the drug trafficking grounds of inadmissibility. And then moving to grounds of deportability under 237, there are also CIMT grounds there, but then you also have controlled substances violations and firearms related offenses and relevant aggravated felonies, in addition to other grounds of deportability. And so again, today we're going to be talking about recent Seventh Circuit law on controlled substances and firearms related offenses. But we'll have other trainings in the coming months on other grounds of removability, like the domestic violence and child abuse neglect grounds. So we'll go deeper into those later. So let's start with drug offenses. So if a substance of the conviction is listed under the federal drug schedules, that will make someone deportable under INA section 237. Under 237, though, there is this exception. If the substance involved was 30 grams or less of marijuana, including marijuana paraphernalia. And then under 212, under inadmissibility under section 212, it's the same idea where you have the substance of a conviction or an admission to an offense is also related to the federal drug schedules that would also make someone inadmissible under section 212. But under 212, this includes the possession of 30 grams or less of marijuana. So that's the main difference for marijuana purposes between deportability and inadmissibility. And so just a quick overview of the categorical approach, which you'll see will come into play very quickly. Sorry. So if the state drug offense, which is, most of the drug offenses that we deal with, they must match the federal CSA, the Federal Controlled Substance Act, for there to be immigration consequences. So what that means is if a state punishes substances that are not on the federal schedule, the federal CSA list, then that offense is overbroad. So what that means is we have these two, little circles here that you have to make sure that the state offenses actually line up to the federal counterpart, because if they don't, then the conviction could be overbroad and then would not carry immigration consequences. So there are, when we talk about overbreadth, I think it's helpful to think about this with two levels of comparison. So the first level is somewhat straightforward, where you're comparing the state and the federal lists for controlled substances. So you look at the relevant state list, like the Illinois Controlled Substance Act, and you compare it to the federal list to see if a drug on the Illinois list is not listed federally. But then there's another useful tool as well, where you actually should compare the state and federal definitions of the specific controlled substance. And so what that means is sometimes the schedules use another list to describe or define the specific substance. So you really need to look at how the state will actually defines the generic term of the substance. And sometimes we've seen courts, when it's ambiguous what the definition of a substance is, courts look to legislative intent at times to determine what the definition is. So here's our first hypothetical. This is Illinois possession of a controlled substance under section 402C. So it is unlawful for any person to knowingly possess a controlled or counterfeit substance or controlled substance analog. It's pretty general, and it refers to all controlled substances defined under Illinois law. And so we'll just tell you now that in looking at the two different drug schedules, salvia is a controlled substance under Illinois law, but it is not a controlled substance under federal law. So here's the question. What do you think? Is a conviction under 402C, would that qualify as a controlled substance offense under the INA? And we have a little poll for you, an anonymous poll. Please, we'll give you a minute to answer that poll.
Don't be shy, it is anonymous.
It's anonymous.
Okay.
Okay.
I think we've got about 40 people out of 54 participants responding.
Great.
So yeah, sorry, most folks answered no. About 33 people said no. There were a handful of people who said yes.
Great. So the answer is no. And here is the case that the Seventh Circuit came out with that answered that exact question. It's called Nahara Rodriguez v. Barr. Let me address, I'm sorry. So Nahara was convicted of possessing a controlled substance under 402C, and he actually possessed Xanax, which is a federally controlled substance. But as we talked about, the Illinois statute covers at least some substances, salvia, that were not included under the Federal Controlled Substances Act. And so the holding of the Seventh Circuit was, look, it's therefore possible to violate 402C in ways that do not fall under the Federal Controlled Substance Act, which is the trigger for removability under 237. So that means 402C is categorically overbroad. And the Seventh Circuit also went to the next step in the analysis to say that 402C, in addition to being overbroad, is not divisible as to controlled substance, and therefore a modified categorical inquiry is inappropriate. And so we'll get into this a little bit later, but that's also important. When something is overbroad, you still look to see if it is divisible. And so the outcome of Nahara is pretty significant. It means that all convictions under 402C are categorically overbroad and therefore have no immigration consequences. And this is the case even when an individual's conviction is actually for a federally controlled substance. And so even in Nahara's case, the substance that he actually possessed, there was no dispute that it was Xanax, which is a federally controlled substance, but that doesn't matter for the categorical approach. You look at the statute of conviction. So here's our next hypothetical. We're looking at 401C2, which is dealing in cocaine in Illinois. And so that statute punishes the manufacture or delivery of 1 gram or more, but less than 15 grams of any substance containing cocaine or an analog thereof. And so as you may not be surprised to hear, cocaine is included under the Federal Controlled Substances Schedule. So here's the question. Does this statute match the federal CSA for purposes of removability under the INA? Okay, great. So what do we think? Okay, so we have a lot of yeses. So before we answer this question, I have to say this is a bit of a trick question. And so before we get to the case that came out recently on this, here's a little note on terminology. Sorry. I promise this is the most science that we'll deal with in today's presentation. But for those of us who forgot about organic chemistry or never took it in college, it's important to know what an isomer is. An isomer is a molecule with the same chemical formula as another molecule, but its atoms are arranged differently. And that's all we really need to know for purposes of the next couple of cases. But you can see this example here, C2H6O, those are two isomers, ethanol and methoxymethane it's the same chemical sequence, but they are arranged differently, and so they're isomers of each other. And so under Illinois law, we need to look at the definition of cocaine, because again, when you just look at cocaine and compare cocaine in Illinois to the cocaine under the federal schedules, you need to dig a little deeper. And so cocaine is defined under Illinois law as coca leaves and any salt compound isomer, salt of an isomer, etc. And if you look at the bottom of the definition, for the purposes of this paragraph, the term isomer includes optical, positional, and geometric isomers. And importantly for us, under federal law, only the optical and geometric isomers of cocaine are federally controlled, are controlled substances under federal law. So what do you think now then, without knowing precisely what is an optical, positional, geometric isomers, now what do you think, knowing that the definition of cocaine includes optical, positional, and geometric isomers under Illinois law, but under federal law, it only includes optical and geometric isomers? What do you think? We'll poll you now on that.
Okay, I think about 60% of people have responded now, so we'll end the poll and share the results there.
Okay, great. Yeah, so this definitely changed a lot of people's answers. And so now let's go to the Seventh Circuit case that decided this exact issue. And so the answer is, that's correct. Most of us got this, that cocaine, the definition of cocaine under Illinois law is categorically overbroad. And that means Illinois dealing in cocaine under 401(c)(2) is also categorically overbroad. The Seventh Circuit looked at this exact issue of the 3 different types of isomers. And if there are 3 different types of isomers that are included under Illinois law, but federal law only includes 2 types of isomers, that means you could be convicted under that 3rd type of isomer, the positional isomer of cocaine under Illinois law. So that means it's categorically broader. And what's important too is that the Seventh Circuit said, on its face then, the Illinois statute is categorically broader than the federal definition. And we'll get into this more a little later, but it is facially overbroad because of the isomers involved here. And the Seventh Circuit in Ruth also said that section 401(c)(2) is not divisible as to controlled substance, similar to the Nahara case that we just spoke about. And so you can't go into a modified categorical inquiry to determine whether the actual substance was a positional isomer or not. So here's another hypothetical from an Indiana dealing statute. And this is just the Indiana's general dealing in a controlled substance offense. So this punishes this punishes the dealing Sorry, we keep, okay, doesn't want me to go back on this, but I'll just explain the, what happened in this case. This case came out right before the Ruth case that we just talked about. And the issue here was very similar, except it was for methamphetamine. And methamphetamine had, under Indiana law, it also had more types of isomers than under the federal definition. And so the Seventh Circuit in that case said the exact same thing as it eventually said in Ruth, was that if there's this mismatch between isomers under Indiana law versus federal law, and more isomers are included under Indiana law, that means the statute has to be overbroad.
We can do the poll if you want.
Do the poll?
Dave, yeah. Do you want me to go back this slide? I'm not sure why. Every time I try to pull up the poll, I think it starts moving the slides forward and backward.
I think it's fine.
Oh, it's right there. Okay.
Okay. Yeah. And so this was the question, and it's so we could try the poll again if you want to see. I just told you the holding of the case, but this is where you could see it. It's the optical, geometric, and positional isomers of methamphetamine, which is a substance under Schedule 2 of the Indiana Controlled Substances laws. But under federal law, only the optical isomers of meth are included. So what do you think? Is that overbroad? Or could that be an aggravated felony drug trafficking offense?
People are still weighing in. Looks like the count is still climbing, so I'll give people a chance to respond.
We'll count all the votes here, I promise.
Okay, we've got about half of the participants responding to this one.
Great. Yeah. And that's the correct response, is that this won't be an ag fel under the INA because of the overbreadth of the Indiana statute. Great. And we know that from this De La Torre case from the Seventh Circuit from 2019. So then here's a note on how the Seventh Circuit got there in De La Torre, which is a little bit different from the Ruth case, which was the cocaine isomer case. In De La Torre, under Indiana law, there was no express definition for isomer in the statute. Like if you remember from Ruth, it did specifically define that, cocaine and the isomers of cocaine. But in Indiana, there was no express definition for meth and isomers. So what the Seventh Circuit did was it came to its holding, its conclusion, by interpreting legislative intent in that case. And it did so by viewing the structure of Indiana's CSA as a whole. And so that's just a useful bit of information for us, because even if we don't have this express definition, we can make creative arguments as to legislative intent for overbreadth purposes. But I will note that since this decision in De La Torre, the Indiana legislature has obviously read that decision and has gone back to define isomer by statute, so that it is consistent with the federal definitions for meth and even other substances. And so that is effective as of this past July. So that's important for if you have clients with certain offenses. It really does matter when they were convicted or when they actually committed the offenses for purposes of these statutory overbreadth arguments. Okay, so then just a little more on controlled substances. A question that often comes up is, does the sentence for a controlled substance offense or the amount of drugs matter? And the answer to that is generally that does not matter. The exception is, as we spoke about earlier on in the presentation, it must be 30 grams or less of marijuana to avoid removability under the INA 237 grounds, or to qualify for a waiver to overcome inadmissibility. And another question is, are all felony drug offenses aggravated felonies? And the answer to that is no. Simple felony possession offenses usually aren't aggravated felonies. And that's from a Supreme Court case from about 10 years ago. And there is a narrow exception if you're charged as a recidivist. But we also just want to let you know that this could still trigger deportation under INA 237 as a controlled substance ground. But it would not necessarily be an aggravated felony offense.
Okay, thank you so much, Dave. So we're gonna delve now into the relevant aggravated felony grounds with the drug trafficking aggravated felonies as defined in the INA, and then we're going to move on to the firearms offenses and other relevant offenses. Okay, so as Dave already gave you a hint of this and some of the developments for the controlled substance offenses, that is very much relevant to the analysis of an aggravated felony for drug trafficking purposes. But I'm going to take you back to the basics right now, and we're going to start off with how the INA defines an aggravated felony, and there are two ways in which the drug trafficking aggravated felony is defined at 101A43B. So first, an aggravated felony drug trafficking offense is defined as illicit trafficking in a controlled substance as defined by the Controlled Substances Act, including a drug crime as defined in section 924C of Title 18 of the code. So first we're going to talk about the illicit trafficking. So the board has interpreted illicit trafficking to be distinct from the drug trafficking clause. So illicit trafficking, the first part, drug trafficking crime, the second part of the definition, and either of which is sufficient to constitute an aggravated felony offense. So a state offense could be an illicit trafficking offense, or it could be a drug trafficking crime. So we're going to look at both of those right now. Okay, so the illicit trafficking prong of the definition is defined as any state, federal, or qualified controlled substance offense as defined in section 102 of the Controlled Substances Act. And we gave you some citations here for the relevant BIA case law that discusses this. And in those cases, particularly the more recent case of matter of Sanchez Cornejo, the BIA looks at this and says the illicit trafficking, there are three parts of the definition. So the state drug offense must be a felony under the law of the conviction. It must involve unlawful trading or dealing, and in a federally controlled substance. So there's three sort of elements or three prongs to that definition. For the drug trafficking crime, under this clause, the state drug offense is an aggravated felony drug trafficking offense. It prescribes conduct that would be punishable as a felony under the Federal Controlled Substances Act. And for this one, you can look at Lopez v. Gonzalez and Moncrief v. Holder. And I'm going to talk in some detail next about Moncrief v. Holder. So there's the two prongs that you need to be concerned with and analyze the state statutes under. Okay, so Moncrief v. Holder, this is, an older case, but it's still very, very relevant for how we analyze the aggravated felonies and the more recent developments in Illinois for aggravated felony drug trafficking offenses that are related to our statutes. Okay, so we'll start off with Moncrief v. Holder here. So Moncrief is the Supreme Court case from 2013. It was an opinion written by Justice Sonia Sotomayor. In that case, Moncrief, he was an LPR from Jamaica, and he was convicted of a Georgia misdemeanor offense for possessing 1.3 grams of marijuana, so a very small amount. And he was convicted of a possession with intent to distribute. And generally speaking, offenses that involve more than simple possession, that are intent to deliver or trafficking, distribution, those are going to be, generally speaking, considered drug trafficking offenses. So the argument in Moncrief was that his conduct that under the state statute did not require remuneration, did not require some form of exchange of something of value, of compensation, and that would not be punished under the Controlled Substances Act, because under the Controlled Substances Act, it would not be punished as a felony. And so therefore, the argument in favor of Moncrief was that this would not qualify as a felony under federal law. And the Supreme Court agreed. In a majority decision, I think there were 2 dissenting votes there, but almost all of the justices agreed, because Georgia prosecutes the possession of small amounts of marijuana that can be distributed without a requirement of remuneration under Georgia law. This is not a drug trafficking aggravated felony, because it would not have been treated as a felony offense under the Controlled Substances Act. And so the court referred to this social sharing of marijuana, right? That if the state punishes conduct that would be considered social sharing of marijuana for a small amount of marijuana, then that is not an aggravated felony, drug trafficking aggravated felony to trigger that ground under federal law. And so Mr. Moncrief then became eligible for cancellation of removal for lawful permanent residence, which he was otherwise barred from applying for, because the government had charged us as an aggravated felony. Okay, so now let's look at how this is, do I have a poll here? I think I do. How this is interpreted in Illinois, okay? So in Illinois, we have a statute for manufactured delivery of cannabis, and this is a case citation. It's under 550 5D, and it says that it is unlawful for any person knowingly to manufacture, deliver, or possess with intent to deliver or manufacture cannabis. Any person who violates the section with respect to, and there are different subsections with the amount. The first subsection is 0 to 30 grams of cannabis. And then there is, it builds up from A to B to C to D. D is for more than 30 grams, but not more than 500 grams of substance containing cannabis, is guilty of a class 3 felony. And for this question, what you should know is that the definition of deliver in Illinois, it's defined as the actual constructive or attempted transfer of possession with or without consideration, whether or not there is an agency relationship. So again, here, with or without consideration, the consideration again speaks to the remuneration. Is there an exchange of something of value? And it doesn't have to be money, but does the statute require that there's something of value that's exchanged? Here in Illinois, there's no requirement for that consideration. So is this an aggravated felony? So I'll just wait for folks to chime in here. Okay, so this one's a little bit more straightforward, right? Once we walk through Moncrief, but I'm just going to give people more of a chance to respond. There's still some folks coming in. Okay, so about half of folks have responded now, so I'll end the poll. Okay, so most folks said no, this would not be a drug trafficking aggravated felony. That's correct. So again, under Moncrief, that would not be that is correct. And I'll talk about the case. So you might be wondering, for those of you who said yes, right? You might be wondering like, hey, but 30 to 500 grams, that is not a small amount of marijuana, right? The 500 grams is like way more than the 300 grams that the Supreme Court was talking about in Moncrief. And yes, that is something correct to point out. However, you know, astute immigration lawyers, as we have in Illinois, really pushing the envelope and really pushing the envelope with these arguments. So we have a Seventh Circuit case, Chen v. Sessions from 2017, in which immigration attorneys did just that, tried to push it, right? So the argument in Chen was that, again, when you're applying the categorical approach, you're looking at the minimum conduct that's punishable by the statute. And under this subsection of the marijuana statute in Illinois, the possession could have been just for 30.0001 grams of marijuana. So on the lowest end of the scale, right, between 300 and 500, you still, and sorry, that should say the 500, right? You could still have someone convicted for just a tad more. And so the Seventh Circuit found, yes, this statute punishes possession of just a tad more than 30 grams, as that's the lowest amount. And that would not have been punishable as a felony under the Controlled Substances Act, and therefore, again, following Moncrief v. Sessions, this is not an aggravated felony drug trafficking offense. And I'll say, so because we're talking about Illinois, we focused on the Illinois examples, but this is also applicable, and you may see in your practice, Wisconsin THC statute, so THC also meaning cannabis. In Wisconsin, there's a statute for delivery, distribution, trafficking, possession with intent to traffic THC. And their lowest amount, because their ranges are just so high, their lowest amount is of 0.001 to 200 grams. And so in their first category of offenses, you have the statute that punishes what could be, a really teeny tiny amount, and certainly less than 30 grams, but even up to 200 grams. And under that statute, we've argued successfully under Moncrief that that is not an aggravated felony, and it shouldn't trigger that ground of deportability. It shouldn't bar people from relief under cancellation of removal, lawful permanent residents who are otherwise eligible. But note, however, that these offenses are still going to be considered controlled substance offenses unless you find, another argument, right, that perhaps the definition of cannabis is different between the state law and the federal law. And there may be some arguments there. Dave and I actually just participated last week in a training that was provided by the National Immigration Project and the Immigrant Defense Project that was similar to this training, and they talked about how there are some small differences in how cannabis is defined at the state level and at the federal level, and there may be some ground there to challenge that. But that's sort of like the next step or the next horizon in terms of trying to challenge some of these definitions. As the states are, further decriminalizing the behavior or may criminalize more than how it's defined under the federal statute, because the federal statute is also sort of loosening its definition of cannabis, as you have more of these, hemp sales and CBD sales and stuff like that. So there's change there too. So just keep your eyes out for possible developments in those definitions. But Moncrief, Chen, it really goes to not the definition of cannabis, right, but the definition of the whether it requires remuneration, whether the social sharing would be punishable so that it doesn't meet the definition of a felony under the Controlled Substances Act. So that's the argument there. Here again. So, so it's critical to check the state definitions, to check the federal definitions, to do that comparison. And as Dave said earlier, the really important thing for us to be checking is when you might ask, sort of what are the relevant dates? So you really want to be checking at when your client was convicted and what was the statute of conviction when your client was convicted, what was punishable under the state there, and what was punishable under federal law at that time of conviction. So that's the critical timing. You want to be comparing sort of apples to apples. If you're comparing what was punishable then and what is punishable now, that might not fly. It's more of an apples to oranges comparison. So you really want to be looking at the dates of conviction for that comparison and that analysis. And I just want to say, we're going to move on to talking about realistic probability, but again, I just want to emphasize that as Dave said earlier, not all controlled substance offenses are aggravated felonies, right? The simple possessions, they're generally not considered aggravated felonies unless there's that recidivist statute based on the older case in Karachuri for the Supreme Court. So generally speaking, your simple possessions, right, are not going to be aggravated felonies regardless of the amount, regardless of the sentence. And on the flip side, you always have to consider whether a drug trafficking aggravated felony offense is still a controlled substance offense, right? So again, in Moncrief, that one, it's not an aggravated felony drug trafficking offense. However, it's still a controlled substance offense under, relevant BIA case law and circuit case law. It still triggers the controlled substance offense, again, unless you have an alternative argument that, the substances punished under that statute are overbrought themselves, and there's another sort of layer of categorical analysis in that regard. So again, you have to consider whether it still triggers a controlled substance offense, and the person, though an LPR, may still be removable because, especially if the amount is over 30 grams. Okay, so we've, in prior trainings, we've gone a little bit more in depth in the categorical approach and the modified categorical approach, and we've talked about realistic probability, and I hope that some of you were able to attend those trainings that we did back in the spring. But we just want to emphasize here again that the realistic probability test does apply, and the realistic probability test is sort of a check on the categorical approach. And in this Supreme Court case, Gonzalez v. Jonas Alvarez from 2007, the Supreme Court said that it's a check on the arguments about whether the minimum conduct punishable, whether you can show that there was a prosecution about that conduct, and it's not just defense counsels or counsels for the petitioners coming up using their imagination to come up with like wild hypothetical speculative situations in which conduct might be punishable under the state statute that wouldn't otherwise fit the ground of removability. And, in that case, they said, well, you have to show that the behavior, that there's a prosecution. And the BIA has, sort of the way that they define that successful prosecution. They have doubled down on, like, you have to show that that behavior was prosecuted at the state level. And this is, quite, and I can go into this more detail on here. So, it requires a realistic probability, not just a theoretical possibility that the state would apply the statute to conduct that falls outside of the generic definition of a crime. As I said, the board takes this a little bit further, and the way that they apply it to controlled substance offenses is quite strict and very concerning, and certainly something that should be challenged, is being challenged across the country. And we don't yet have a decision on this in the Seventh Circuit, but it is important to note that the board applies this test to say that you do have to show that there is a prosecution of the drug that makes the statute overbroad, or the conduct that makes the statute overbroad in this drug context. In the case, there is matter of Ferreira from 2014, and then there's a more recent case from matter of Navarro Guadarrama, where they double down on this requirement, that where even where the state statute is facially overbroad and on its face punishes salvia, punishes substances, isomers, right? The geometric and the positional isomers that aren't punished under federal law, that even under those situations, you have to, the petitioner has to, or respondent has to show that there's a successful prosecution of those things. And that can be very, very difficult, as you can imagine, to be able to show that, especially when it's not the situation in your case. And the court says you can use the situation in your own case to say, hey, I had a possession of salvia, and so, the statute is overbroad, or, I was the one that was convicted for, meth that had those positional isomers, like, but that's really not going to happen most often, right? Most often our clients do have the controlled substance offenses that are punished under the Controlled Substances Act, but the statute itself is overbroad. And so what we want to try to push is that because the statute on its face punishes the overbroad, the overbreath is on its face, and it punishes the salvia, it punishes those isomers that are not defined under federal law, that satisfies the realistic probability test and that requirement. But so far, that has been difficult, to say the least, at the Board of Immigration Appeals. However, the state laws, the circuits have supported our argument that the overbreath on its face, when the statute outlines things that are not punished under the Controlled Substances Act, that satisfies the realistic probability, or that the realistic probability test certainly just doesn't even apply to those cases, that's not the scenario in which it was presented in Duenas-Alvarez, and that it shouldn't be required in those situations. And to date, the 1st, 2nd, 3rd, 4th, 9th, and 10th have weighed in on this, and I think it was just the 11th and I think that there was maybe the 5th Circuit does require that, and the 6th Circuit, I believe, are the states that do require that you still show a realistic probability, even where the statute is overbroad. Here in the 7th Circuit, we don't have a case that resolves this question. a couple of years ago, NIJC was litigating a case that had to do with this, and it ended up resolving otherwise in very surprising ways, but that mooted out, and it was not resolved by the Seventh Circuit. So there isn't a case on point on this realistic probability issue. However, we have been arguing with some success, at least before the immigration judges on the detain court, that these cases, Ruth, De La Torre, Nájera, there's another case, Elder, that doesn't have to do with an Illinois controlled substance statute, that had to do with an Arizona controlled substance statute, but it had the same analysis, right? It didn't require, explicitly didn't require that the respondent show a prosecution. So we're saying the courts in the Seventh Circuit here, in the way that they're applying the case law, they're not explicitly requiring this because it's not required in this context. And so the immigration judges shouldn't require it. And it is a tough argument because the Board of Immigration Appeals, explicitly says it is required. But we are getting some traction with that. And we have had we have a couple of cases on appeal right now at the Board of Immigration Appeals. And we have actually just yesterday, Judge Roche terminated a case. I'm sorry, she dismissed a charge of an aggravated felony offense for because of the isomer argument. And she didn't, require sort of that realistic probability. So that is positive, and it's positive movement, that the judges are generally agreeing with us, but certainly it's going to, if the government continues to appeal, it is something that is going to go up to the Seventh Circuit at one point or another. And these cases are also getting appealed to the Supreme Court. So we may have, because there is that circuit split between most of the circuits saying that, the realistic probability test is satisfied, with the exception of a couple, I think the Fifth and the Sixth, saying that it's not. So we may be hearing from the Supreme Court in the next year or so. Okay, so now again, going back to the categorical approach and how the modified categorical approach also enters into this. We want to spend a little bit more time here. So for the most part, the success that we've had, particularly with Nájera, then that was a case that we litigated last year, was that we were really able to argue and persuade the court there that you didn't even have to get to apply the modified categorical approach, right? So the modified categorical approach only applies if the statute is divisible. And where the statute is not divisible, you don't get to look at the record of conviction, and you just look at the disparity. It's overbroad, and you don't apply it, so we win. And that was a great success with Nájera, that we were able to persuade the court that you can't look at the record of conviction to see that Mr. Nájera was actually convicted of possession of Xanax, right? That would have been a loss for us. How a statute, what makes a statute divisible, we talked about in an earlier training in the spring, but generally in a statute to be divisible, it's only divisible if it punishes, if the elements, if you can show that there was a requirement, a jury unanimity, that these things that make it overbroad are themselves elements that had to be found by a jury in order to make it divisible. And so you look at the state case law, jury instructions, sentencing structure to indicate whether these the elements themselves, or the different factual means, are in themselves elements that a jury would have to have agreed upon. And if those are, then the statute is divisible. The modified categorical approach applies. And in that situation, the court is limited to looking at charging documents, plea agreements, a transcript of the plea colloquy, but not the police report. not the probable cause affidavit. So it's still a limited set of documents. One of the important things that I want to highlight here is that for us, we've had quite a bit of success in arguing some of these cases, even in the alternative. So for us, we're lucky when we have, we're dealing with counties, we're dealing with states that are, pretty sloppy in their charging documents. They're pretty sloppy when it comes to their pleas. They're pretty lazy, and they often make mistakes, and they often don't include the substances in the charging documents. They don't include the substances in the plea agreement. And we've seen this both in Illinois. We've seen it out of several counties in Indiana. So it is important right at the outset when you get, your clients, when you know that your client has a conviction, might have a conviction for a controlled substance in one of these states, to get the entire record of conviction and look to see what are the substances that show up there, because sometimes we've just been able to win these cases without the judges having to really look into, is the statute divisible? Is it not divisible? We make the arguments that it's overbroad and it's not divisible, and the modified categorical approach doesn't apply. And alternatively, even if the modified categorical approach does apply, look, our client's record of conviction, the indictment or the complaint just says substance schedule 1 through 4. We recently had a case terminated like that. They were charging him with a controlled substance offense, removable for a controlled substance offense. This was an LPR. And nowhere in the record did it say that he had a controlled substance. And I think he had like some sort of, I don't even remember, it might have been Xanax, I think. It was a federally controlled substance offense that he actually had in his possession, but none of the record of conviction that was permissible under Shepard for the judge to look at said that. The police report said it, but that didn't matter because the judge can't consider the police report. And so we were able to win that argument relatively straightforward without much litigation. And the government waived appeal. They weren't able to get any document that actually showed that our client actually was convicted for a federally controlled substance. And even if he had, right, it wouldn't have been the end of the argument, because we were making also the argument that it's not divisible and you can't even look at those. But even if you do look at those, they can't even show that he was convicted of a controlled substance offense. So I know that's a lot to consider there, but I just want to emphasize that point, that it is important to get those records of conviction early on and be able to know sort of what the options you are for that you have for making those arguments and the likelihood of success in making those arguments. Okay, so we're going to look at this additional example to further explain the application of the modified categorical approach. Okay, so you have this is an Indiana example, and we see this quite often actually in detention, and it's dealing in cocaine or narcotic drugs. And the statute defines knowingly or intentionally manufactures, finances the manufacture of, delivers, or finances the delivery of. The finances portion makes it overbroad, and the government agrees this is overbroad. And actually the Seventh Circuit agrees that this is overbroad. However, there is some case law that says that the statute is divisible as to A through D. And the cases here, the Smith and Williams cases are the ones that you want to look at for that. But again, if you get your client's record of conviction and it says, maybe says A1, but it doesn't say A, B, C, or D, then you have a pretty strong argument there that the government can't show, and it's the government's burden to establish. In many cases, it's the government's burden to establish that this ground of deportability, right? That they cannot show that that your client was actually convicted for the either A or C, and he could have been convicted B or D. Okay, so we are not going to spend much time talking about crimes involving moral turpitude today. And as Dave said, we are planning in the spring, we're going to have we're actually planning 2 more in-depth trainings on CIMTs. One that's going to be focused on like the violent related CIMTs of, your batteries and domestic battery and assault offenses. Crimes of violence as well, and going into some aggravated felonies, and another training on thefts and fraud, and how those interplay with CIMTs. But for today, we just want to make an aside that, that there is some relevance here of CIMTs that you do need to keep in mind with these aggravated felony drug trafficking convictions in particular. But first of all, the simple possession offenses are generally not considered crimes involving moral turpitude. So you don't have to worry about those being charged as crimes involving moral turpitude. However, the board has held that, that drug trafficking offenses are CIMTs. Here are the citation for those cases, the more recent case, J.M. Acosta, and that looks at it's more about the conduct, right, that makes it morally turpitudinous. And so it does make it a little bit more difficult for the judges to agree with us that even where the statute punishes substances that are not, the state statute punishes substances that are not federally controlled substances, and it's overbroad in that sense, that it shouldn't be considered a crime involving moral turpitude, because the Board of Immigration's the BIA says that doesn't matter. The conduct involved in dealing in drugs, even where those are not federally controlled substances, it still makes it morally turpitudinous conduct. And they say a comparison of the federal statute and the respondent's conviction is not necessary in order to do that. And we recently had a case here before, it was actually Dave's case here at with the detained court, where the judge agreed with us. It's not an aggravated felony controlled substance offense, an aggravated felony drug trafficking offense. It's not a controlled substance offense. However, he did have 2 of those. He was a lawful permanent resident. The government turned around and filed a 261 adding the charges of 2 CIMTs, and the judge did sustain the CIMT charges based on J.M. Acosta. So we're going to continue litigating those cases, I'm sure. The 7th Circuit has not yet ruled on this issue, but it might get there as well. Okay, so just before we get to the firearms offenses, and we don't have a ton to discuss there. It's very relevant, and we will discuss it, but we are getting close to the end here. I do want to just make sure to flag for people, and we don't have a lot of time to go very in depth into the reason to believe ground, but just be aware, right, that there is a reason to believe illicit trafficker of a controlled substance under grounds of inadmissibility. That is not present under grounds of deportability, right? So it's just under 212. The big issue with that one is that it is very broad, and it does not require a conviction. And because it does not require a conviction, and it just requires the conduct itself, and the Court of Appeals, the case law on this is limited, but the Court of Appeals, even in the 9th Circuit, held in a case that a probable cause affidavit, the probable cause finding, even where the person didn't end up getting convicted or pleading to the drug trafficking offense, that it still was sufficient to sustain the reason to believe charge. And so it's very broad. It does not require a conviction. The categorical approach doesn't apply, and it's still very much an issue, right? Even if you are able to defeat an aggravated felony charge, even if you're able to defeat the controlled substances charge, you still want to be concerned with this one. Obviously, it's very relevant if you're dealing with an LPR who's returning from abroad and is being charged as an arriving alien, seeking admission with these grounds. And so if you're in that posture, that is very, very limited. But certainly advising clients who, have these convictions that even though they may not be deportable from the United States, if they're within the United States, they should be advised to, against any travel, right, abroad, because the standard is different under 212 once they try to re-enter, and they will be deemed to be seeking an admission, and this reason to believe drug trafficking would apply then, and there could be a finding, there could be a charge based on that, and relief options would be then incredibly limited, if any. So just note that, the overbreadth of these state offenses really has no bearing on this reason to believe ground, and that is something that, we'll have to continue trying to brainstorm and figure out, but for now, definitely advising clients against travel is very important. Okay, so we're getting to the last part now here, firearms offenses. All right, so the firearms offense ground is only under grounds of deportability, so 237 and not under 212. Under the 237 firearms definition, it involves a conviction, convicted for purchasing, selling, offering for sale, exchanging, using, owning, possessing, or carrying any weapon, part, or accessory, which is a firearm or destructive device. And firearm or destructive device is further defined in the US Code. The citation is there. For our purposes, it's important to note that the federal definition does not punish that the federal definition of this firearm or destructive device requires that the propellant be an explosive. And that if the firearm propellant is air, like an air gun, an air rifle, that is not punished under federal law. However, there are some states that do punish it, including Illinois. This is another one of our cases, Rodriguez-Contreras v. Sessions from 2017. In this case, we argued that the Illinois firearms definition is overbroad because it does prosecute and punish air rifles. And again, the air rifles are not punishable under the federal law. And in this case, the Seventh Circuit agreed and found that the Illinois firearms offense cannot trigger removability under the firearms offense or as an aggravated felony. So the Rodriguez-Contreras case itself, that one was an aggravated felony charge. There is some overlap, right, in the firearms offenses, and I'll go up a slide and then I'll come back so you can see the overlap. So, you have several aggravated felony firearms related offenses, including felon in possession of a firearm, an undocumented immigrant in possession of a firearm, possession of a firearm with a defaced serial number, and there's others. These are just some examples. So it is a very, there are a lot of aggravated felony firearms related offenses. And in the Rodriguez case, that one had to do with a felon in possession of a firearm. So Mr. Rodriguez-Contreras was a lawful permanent resident, and he had been convicted of a felon in possession of a firearm under the Illinois statute. And he was not eligible for cancellation of removal because of that. So we challenged this based on this overbreadth of the definition. And we thought that it was going to be an uphill battle because there was a case on point, Negrete, Rodriguez v. Mukasey from 2008, that had found that the Illinois possession of a firearm offense was a federal match to the aggravated felon in possession of a firearm offense. But we weren't dissuaded because the arguments were different, and the law had changed, and the categorical approach had advanced, and different arguments. We had different arguments than those that were advanced in Negrete. In Negrete, the comparison as to the overbreadth was different, and so we were arguing here that Illinois was overbroad because of the air rifles. And so the court agreed. These were not arguments that were raised before, and it is overbroad, and the statute is not divisible as to the definition of the firearm under Illinois. And it was a relatively straightforward decision from the Seventh Circuit on this ground. And so, I think for us, this is really, and I want to note this because it really emphasizes the point about these developments in the categorical approach and, Mathis and DeCamp and Moncrief and all of these cases from the Supreme Court that have been coming out, and we may have more in the context of other grounds soon, that it's very important to keep abreast of those and keep pushing the envelope, right, for these definitions, because we have cases that were decided previously, which found that these offenses are aggravated felonies or do meet certain grounds of removability, but they weren't argued under sort of the categorical approach framework, or even where they were argued under the categorical approach framework, the court was analyzing it in a dated way, in a way that did not actually analyze under Mathis, like, what is the divisibility, and is the statute divisible, or is the statute not divisible, and it just simply has it lists offenses, different means of committing the same offense, but not lists different and separate offenses. So that's something important to consider there. Again, so this is relevant not just for the Illinois possession of a firearms offenses, but also for the aggravated felony offenses. And we've been, successful in arguing that even though Rodriguez arose in the context of the aggravated felony offense, this applies to a possession of firearm offense, any of the firearm offense statutes in Illinois. So it just cannot trigger a firearms-related offense or that aggravated felony for these grounds here. So I think I already stated a lot of this, but it's very important to really compare the statutes, look at the definitions, and when you're looking at, the potential overbreadth, really doing some digging deeper and looking into, how are these substances defined, right? Again, when Dave was looking at that slide of, Illinois punishes cocaine, and the Illinois definition of cocaine appears to be the same as the federal definition of cocaine until you look at how both define isomers, right? So you are digging a deeper level and going sort of deeper and looking at the definitions, and not just looking at like, well, this appears to be overbroad, but really digging deeper into how is this defined, and then at the next level, well, how is this defined, and comparing those both. Again, arguing that the realistic probability test is satisfied when the offense is facially overbroad, and looking at the statutes at the time of conviction, and looking at those divisibility arguments, and looking at whether those cases predated Mathis. And if they did, would they hold up to the Mathis divisibility analysis? And there may be some arguments there. And definitely reaching out to us if you have any questions, if you have any of these cases, if you're looking for sample briefing, if you have cases that you're considering appealing. Some of these cases that we've taken for appeal, and also, for petitions for review to the Seventh Circuit, came from private practitioners that litigated them before the IJ and even before the BIA. So definitely let us know if you have any questions and case-specific things. I think we're both, Dave and I, are happy to answer questions as time allows right now, and in the future. We can also share our contact information on the slides.
And Diana, we got a question about 3D printed guns. The question is, what about, like, how do those factor in?
Oh, that's a very interesting question. I would need to know more about how they work, how they are operated. So, I mean, I think at least for this argument of like what the propellant is, right? If they're still propelled by an explosive effect or explosive device, like if the ammunition has to be propelled through an explosive device, then perhaps it would still fit it. I don't know. I'd have to like look more into, but that's like, it's very technical, right? Like we had to learn about like these air rifles and how are they different from explosive devices, and how are explosive devices. And like, I think that like, we're also looking at like the diameter of the barrels, and it was a little bit complicated. And as Dave said, you know, the isomer arguments also do get a little complicated. So you may need to, you know, reach out to experts. And Dave's isomer case, do you want to talk about the expert that you found, Dave?
Yeah, I mean, at one point, the immigration judge and DHS were caught in this sort of loop of, well, are these positional isomers of meth that you're saying are overbroad, do they even exist in nature? And so the initial argument was, well, wait, under the categorical approach, we're not getting into this fact-based inquiry. Like, why do we even care about this? Like, the statute says it's positional isomers, you know, who are we to decide whether they exist or not? But that didn't work. So I found an expert, a chemistry professor from a college, who gave a declaration saying, yes, positional isomers of meth actually exist, and here are some examples. And so that got us, you know, across the finish line for that particular argument. But that was necessary in that case.
Okay, any other questions? Oh, sort of the same. Okay, I think that's the same. All right, don't be shy. Or if if folks have other, anything that you want to mention. And I'm curious to see if folks have been raising these arguments as well. So definitely chime in if you've had any success in raising these in the past, and or how often you see these in your practice, you know, these types of convictions.
Yeah, and we'll send copies of the slides for those of you who just registered like today. We haven't sent them out to you yet, but we'll send them to everyone at the end of the day.
Great. I can let people chime in as well, just in terms of next steps and housekeeping. We are going to be sending an evaluation after the training. It may not happen today, but it'll certainly happen by Monday. We have it's a little Google survey. It's an anonymous evaluation. And for those of you that are attorneys and are interested in the CLE credit, we did apply for the Illinois CLE credit, and it'll be 1.5 hours of credit. And you have to, after you complete the survey, and we're going to send out the link to the survey, to the evaluation, sorry, which will be anonymous. Then another link will pop up that includes sort of the registration for CLE, and it will just ask for your name, your ARDC number, and your email address, so that we can send you the CLE certificate. But those are ready to go. Once you submit your evaluation and fill out the CLE portion, then you'll get the certificates by email. Okay. Any other questions? Okay, well, I'd like to think that, you know, we just did a really, really awesome job at explaining all of that, which is quite complicated, and that people are being, just being shy. But again, we're happy to answer questions and reach out to us, and we'll also send our contact information with the materials once we send those out on Monday. Anything else? Okay, we're getting lots of thank yous.
Thank you. Yeah. Thank you all for attending. It's great to do this.
All right. Thank you. All right. Goodbye, everyone.
Okay. Bye, everyone. Thank you.